The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting to the dispatch of business. God save the state and this honorable court.
Good afternoon. Our next case is Lannan et al. Versus Board of Governors of UNC. And we will hear from the appellant. I'll note that Justice Berenger is recused.
Good afternoon, Mr. Chief Justice, and may it please the Court. Troy Shelton on behalf of the UNC Board of Governors. I'd like to reserve 6 minutes for rebuttal. In spring of 2020, the world shut down, but our public university system did its best to remain open, and course instruction transitioned to online-only education. By the summer of 2020, illnesses were ramping up and there was no vaccine. For the upcoming fall 2020 semester, the university wanted to get back to business as normal, but also knew that it was acting amid great uncertainty. It decided that most classes in the fall would be accessible through virtual instruction. But the university also warned students that may decide to change all course instruction to online only. And if it made that change, the university warned students, then quote, tuition and fees will not be refunded. That statement was in the cover email sending students their billing statements for fees, and it was in bold and italics. During that fall semester, UNC Chapel Hill and NC State decided to convert to online-only instruction. Then the plaintiffs filed this class action seeking a refund of the fees that they had paid, despite knowing that they weren't entitled to a refund. The question on which this court granted review was whether the trial court erred by denying the university's motion to dismiss the plaintiffs' contract claims. It was error for either of two reasons. First, the plaintiffs do not have proper contract claims, because the plaintiffs were told in advance that there would be no refunds, and that's the simplest way to resolve the case. But second, even if the plaintiffs did have a contract claim, it would be barred by sovereign immunity. For either reason, the opinion below should be reversed. An important issue in this case is the distinction between express contracts and contracts implied in fact. An express contract is one where the words of the agreement and the mutual assent are expressed in words, whether oral or written. But an implied in fact contract exists where the parties' mutual assent has to be inferred from their conduct and not from their words. One of the oddities of this case is that the plaintiffs are here on appeal talking about implied in fact contracts, and let me tell you why. There were two complaints in this case, the original complaint and the amended complaint. In the original complaint, the plaintiffs alleged a, quote, unwritten but legally enforceable contract implied in fact. We moved to dismiss that complaint, and in response, the plaintiffs amended their complaint and abandoned the implied in fact contract theory. All references to implied in fact contracts were deleted, and their place were substituted a, quote, an express contract at least 3 times in the amended and now operative complaint. But on appeal, the plaintiffs have been equivocal about their contract theory, about what they've alleged in their complaint. Now, my friend on the other side is likely to justify this horse switching by saying that both express and implied in fact contracts are equally enforceable, but that's not an adequate response. First, if there's an express contract, there cannot be an implied in fact contract. That's black letter law. Second, this court has never squarely held that implied in fact contracts waive sovereign immunity, and there are very good policy reasons to reject that, as I'll get to in a moment. But if this is not an implied in fact contract case, then there's no sovereign immunity issue for the court to address. Now, regardless of the contract theory, the plaintiffs should still lose their contract claims because they have failed to plead mutual assent for a contract claim, and for 2 reasons. First, the plaintiffs' arguments about the no refund language shows that the parties did not agree to the same thing about fees. The plaintiffs have the burden of pleading that the parties agreed to and intended the same thing with respect to student fees.
Well, this is where I struggle a little bit with your argument because, so take, for example, paragraph 47 in the complaint where they allege that the plaintiffs received an itemized bill that labeled in writing services and benefits that the universities promised to provide in exchange for the students' payment of those student fees. And I understand that there's a whole bunch of things that are beyond the four corners of the complaint saying, well, that's not really what happened. But isn't that enough to plead an express contract? That seems to me to have all the elements of a contract, because we will send you this statement that says you pay this amount, and then we promise you in exchange we'll give you these services. Isn't that a express contract?
That's not enough, Your Honor. So if you look at page 57 of the record, starting at paragraph 32, this is where they're talking about the description of the fees, and they in fact quote the description of the fees throughout the amended complaint. But the problem for them is that none of the language here is promissory. They're saying that
Okay, so I follow you on that, but here's the thing. Like, imagine you just came into court and it said complaint, and it said, I promised to mow my neighbor's lawn, and in exchange, my neighbor promised to give me $50. End of complaint. And you couldn't come in and say, well, but you didn't describe in the complaint the exact promise that you offered them, that they offered you. I mean, the idea is you just have to allege facts that would support the existence of the express contract. And it seems to me that if we get past the Rule 12 stage, especially because I don't even think you need to go past the Rule 12 stage, because you did a Rule 12b1 and a 12b2 motion, so you could just say, Your Honor, we need a little bit of discovery on the sovereign immunity that we think is one that has some fact issues. So we just want to do sovereign immunity discovery, and you just submit one interrogatory, and it says identify all the oral or written promises that you describe in the complaint that you say form this contract. And then when they answered that, you could come to court and say, Your Honor, look, this is not an express contract as a matter of law. But don't we need to take the plaintiff's word for it at this stage when they say there's a promise out there in a bill somewhere that's enough for the contract, even though the rest of the things they're describing in the complaint sure don't seem like they're creating one?
The problem, Your Honor, is not that they have pleaded too little, but perhaps that they've pleaded too much. They say that this language, where I was just directing, Your Honor, in the complaint, they say this is the contract. At page 26 of their brief to this court, they say that language right there, that was the offer. So if you're agreeing with me that that doesn't look like contractual language because it's not promissory, because in fact, nothing is being promised in exchange for these fees, then they have pleaded themselves out of court, because this is not a contract.
So when they use the word promise, then your position would be that that's a conclusory statement.
That's right, Your Honor. That's a conclusion of law, whether it was a promise. And since they have pleaded the facts here, they say these words, this language that was exchanged between the parties, this is the contract. They said it also before the trial court, page 17 of the transcript. So I think that we should, and that's what they said at page 26 of their brief to this court, so I think that we should take them at their word. They said, these fee descriptions, these are the offer. This is the terms of the deal.
But
Now,
I mean, doesn't that part say, like what you were referencing on page 57 of the record, these are things where they're saying this is how the university described these fees, but it doesn't say where. And then when you look at the paragraph where they say they sent us this bill, and in the bill they promised that we would, if we paid these fees, we would get these services in exchange that we didn't get. Don't we need to assume that that's making a factual allegation of some sort, that there's some document out there that shows that that your clients made this promise?
So these fee descriptions here, that's the bill, Your Honor. That is the billing statement.
But do we know that from the four corners of the complaint? That's what I'm asking.
I believe so. I mean, I think that is at least how I interpreted the complaint, that this is what the billing statement said. These are the fee descriptions. This is what your fees are going to. And now, so my argument for the lack of a contract goes both to, there's a lack of promissory language here, because that's the promissory language that they are relying on, but also the no refund language. Now, and I don't believe that the no refund language is outside the four corners of the complaint. My friend certainly has not, on the other side, certainly has not argued that you shouldn't consider the no refund language. It's referred to in the complaint, and that's why we attached it. Of course, that on a 12B1 and 12B2 motion, the trial court can look at documents outside the pleadings, but we think that it's fairly encompassed within the pleadings. And that no refund language shows that the parties must not have agreed to the same thing about fees, because the plaintiffs say, well, they intended to have a refund for the fees, but the university very clearly told the plaintiffs that there was not going to be a refund of fees. So the plaintiffs essentially face an impossible dilemma on the no refund language. Either there was no mutual assent about fees, in which case there is no contract and they lose, or there was mutual assent about fees, that there wasn't going to be a refund of fees, in which case there is no breach, and so the contract claim still loses. Either way, it's not a good contract claim.
Is there no contract, or is it that there was a contract, but the payment of the fees, what you got in exchange for that was registration and the ability to continue attending the university?
Well, it's the university's position that when it comes to fees, that it's simply not a contractual relationship. So as to mutual assent, I'd say the parties just, I believe that one way of looking at it is they didn't have a meeting of the minds about fees and refunds. Another way of looking at it is if they had a meeting of the minds, then there just was no breach because there was a meeting of minds as to no refunds. But I want to emphasize that to the university, at least when it comes to fees, this is not a contractual relationship. Once a person becomes a student at the university is statutorily empowered to assess fees against the students without the students' consent and without giving the students anything in exchange for the fees. And those are the two ingredients for a contract: mutual assent and consideration.
Are you saying that there's no correlation between the amounts that were charged in each of the fees and each of the subject matter? So in other words, when they charge $400+ for medical care or the availability of medical care, that really doesn't matter. It's just a number that was just kind of drawn out of thin air.
No, I don't believe that's correct, Your Honor. I think that the university probably has a duty by statute to assess costs that have a reasonable nexus to the actual costs incurred by the university.
Of the service to be provided?
Not all these are services to be provided to a student, for example.
To be available?
I'm sorry, Your Honor.
To be available?
Not even to be available. For example, some of these fees are going to paying off bond indebtedness. You can't have a contract for paying off bond. The students aren't benefiting from paying off bond indebtedness. Some of these athletic fees, they go to supporting the athletic teams and their equipment. It's not for the student spectators. It's not for their benefit. It's for the athletes' benefit. It goes to pay the staff.
Well, let's talk just a minute about the parking fee. Is that totally disassociated with the ability to park?
So the problem with the parking fee claim is that there is no breach of contract at all when it comes to the parking fees. Now, my friend on the other side won't dispute that they were allowed to park on campus. They don't allege that they weren't allowed to actually park and use their passes. Now, and you have to of course, they're going to come back and say, well, you essentially deprived me of all the meaningful benefit when you transitioned to online-only education. But think about where we were when the students were buying the parking fees in summer of 2020. The world had just shut down, was still pretty much shut down in summer of 2020. They were already being told that there weren't going to be any refunds for any purchase, for any payments, for any fees that they're paying to the university. So when it comes to a contract claim, the parking pass claim is a little bit separate, but it's really the worst claim because there's simply no breach when it comes to the parking permits.
So going back to the medical facilities or the availability, if a student can't be on campus, why does it make sense that they should have to pay for medical care that is unavailable? I mean, did the university offer telemedicine to them?
Yes, the university did offer telemedicine. And of course, we also charge these same fees. Things that are clearly on-campus related types of things to students who are studying abroad. This is just the fee schedule that every student pays, whether they're available, whether they could take advantage of the fees or not, or excuse me, of the services or not.
But isn't the discussion that we're having more for summary judgment and not for, at this stage, where we just look at the pleadings and take all the allegations to be true.
Of course, the point about telehealth, that I agree that I understand that is outside the record. But at the end of the day, the university has the power by statute, not just the power, but in fact the duty. It's required to charge fees, but it also has the power to charge the fees, whether the students agree to pay the fees or not, and regardless of whether the university gives anything in exchange. Now, maybe the university does or doesn't give anything in exchange, actually gives consideration, but it's not required to by the statute. And that's what we mean when we say that this is a statutory relationship and not a contractual relationship. We've analogized it to taxing power. It's not a tax, but I think that can be a way of looking at it, especially when we think about bond indebtedness. Of course, that's how you pay off at the local government level bond indebtedness, through taxing. You're assessing payments that people have to pay. So
You mentioned local governments. Local governments charge fees for all kinds of things. Would accepting the plaintiff's position turn all of those transactions into contractual?
Absolutely. I think that anytime there's something, my friend says, if you're using the word fee, then it is, it's inherently contractual. We pay court fees, we pay DMV fees, local governments charge fees, local water and sewer services, all sorts of fees. And there are really no cases suggesting that those are contractual. Now, of course, sometimes the government's, you pay the fee and the government provides a benefit, but it's not contractual at the end of the day, because the government has the power, certainly under our statute and probably under many of the local government statutes, to assess the fee, whether the homeowner wants to pay the fee or not, like a tap fee or something like that.
So to go back to the parking fees, I just want to be sure I understand. So those are different from the other fees in that not every student pays them. Only those students who want to park. Is that right?
That's right, Your Honor.
And so I understand that you're arguing there was no breach, but are you denying that there was a contract?
I would still deny that there's a contract, because at the end of the day, we believe that the parking permits are fees like the other fees, and that if we want to, we could assess a parking fee against everyone. Now, we don't do that, but we could, and it's because we can do that it's not it's an inherently not contractual relationship.
Wait, so if you could do it through a universal fee, then that means a fee in any particular case can't be contractual?
Yes, I think that the fees that the fee statute that we're talking about here, we are following the fee statute. Doesn't require assent and it doesn't require consideration. So those fees, when we charge them, are not contractual, and so we are not in a breach of contract. You can't have a breach of contract when it comes to those fees, and so we never even need to get to the issue of sovereign immunity. But I do want to touch on sovereign immunity before my time is up. Implied and fact contracts ultimately are not appropriate as waivers of sovereign immunity. This is, of course, assuming that the court ignores the allegations in the complaint of express contract and treats this as the appellate brief, the appellee's brief calls it an implied and fact contract. This court has repeatedly emphasized that immunity waivers are not to be lightly inferred, but instead are to be strictly construed. In the Guthrie case, this court explained that the state is immune unless it has, quote, expressly consented to be sued. And we think that under those principles, implied and fact contracts are inherently too ambiguous to constitute immunity waivers. If the legislature disagrees with that proposition, it can, of course, pass a statute that would waive immunity for any kind of implied contract. In fact,
isn't the problem with that argument that it really runs in the reverse, that our case law just says when the state enters into a contract, it waives sovereign immunity. And implied and fact contracts are contracts. The law does not distinguish between, in terms of their enforceability, the implied in fact or an express contract. And I'll get into this with your friend, but I think part of that is because the idea is through your actions, you did express that intent to enter into the contract, which would be the thing that our case law says waives sovereign immunity. So I understand, and I've seen the amici's argument about the sort of slippery slope here, but it just seems to me if the state puts out a lemonade stand and it says lemonade $1, and people come, there's a state employee behind the lemonade stand, and people come up and they hand $1, and then they're still standing there, and the person says, well, goodbye, have a nice day, and keeps the $1. It would seem to me that's exactly the sort of contract that we would say waive sovereign immunity. If you're going to set up that lemonade stand, you can expect to be sued, and there's clearly a contract there. So a reasonable person would understand you're handing the $1 over because you're buying one of the $1 lemonades. I mean, why shouldn't we just treat it that way?
So I agree that with your lemonade stand is probably a contract, but I would disagree that it's an implied in fact contract. I would say if you've got a sign out there that says, here's the terms of the deal in writing, that's an express contract, not an implied in fact contract.
Well, but isn't the problem that we never said, hi, this $1 is for the lemonade? I mean, isn't that the paradigm of an implied in fact contract? It's like you go into the barber shop and you sit in the chair. You never spoke to the barber never talked to you, cuts your hair. That creates an implied in fact contract. In the ordinary course of dealings, everyone knows why you're there, you're getting a haircut, you're going to pay, the barber's going to cut your hair. Same thing. And it would only be if you actually expressed your intent to be bound that you could say it's an express contract. Isn't that how it works?
So I guess in your barbershop example, I would agree that that's it. If you sit down the shop, then that, and you get your hair cut, then you've got to pay. That's an implied in fact contract. No,
you think if there's a sign though on the barbershop door that says haircut's $20, then it's not an implied in fact contract anymore, it's an express contract?
I think that the offer of it is express. The acceptance, if you just sit down in the chair and don't say, please cut my hair, I agree to the terms, and you're accepting through conduct. But I would say that the offer is express. And so in a situation like that, at least for sovereign immunity, now most of the time, the distinction would be irrelevant, right? We're having a somewhat academic discussion, but I think it's a discussion that we should have when it comes to sovereign immunity, because I actually think those are pretty different situations, because the government has a lot of control when it writes down the terms of the offer and expresses them. So, when the government wants to contract, it doesn't do so through its conduct. It does so expressly, almost always in writing. Of course, it doesn't have to be in writing, but almost always in writing. But if any party can just come to court and just allege that the conduct has waived sovereign immunity, then there's not going to be much left of sovereign immunity, because that's a very easy allegation to make. Now, Justice Allen noted earlier, public agencies provide lots of services. So what's going to happen if the provision of those services is deemed to be implied in fact contracts? I think this case is a really good illustration of the problems with that. Let me give you a couple examples. Consider a very recent example, Hurricane Helene. Of course, when we wrote our brief, we certainly weren't imagining hurricanes hitting the western part of the state. But now that they have hit the western part of the state, which was a rather unforeseeable occurrence, the universities are of course changing their operations. I mean, I assume my friend on the other side would come in and say, well, that's breach of an implied in fact contract. And here's another recent example. One of the fees that's alleged, and for both NC State and UNC, are fees that go to support those schools' diversity, equity, and inclusion offices. But the Board of Governors just ordered that DEI offices across the entire system be shut down. Are all those students owed a refund of their fees? And consider something more mundane. The University of North Carolina has put on a concert on the Quad each semester for the past 10 years. This coming semester, they decided not to put on a concert in the Quad. Was that a breach of an implied in fact contract? I think yes, under my friend's theory. But I think the problem here...
Don't we avoid all this if we just realize that your friend's theory, which is, to be fair to your friend, the Court of Appeals theory is just wrong. That that's not what implied in fact contracts are. That there's another element the Court of Appeals never mentioned, which is that in the ordinary course of dealings, this is the only terms that could have been intended by the parties here. That's what allows you to have the implied in fact contract. In all the hypotheticals you just described, it's not clear at all that there was only that one possibility. Just as the case here, the funds they might be refundable, the fees, or they might not, and that's why you need an express contract. It's bargained for so that you know which of those two it is.
Sure, I think they were wrong, of course, to consider it as an implied in fact contract, and I'd rather you just say that there was no contract at all, of course. But I think the problem is that, I mean, they're onto something. I mean, you could theoretically have an implied in fact contract, but I think that the student-university relationship is too complex. The barbershop example is fine, or the lemonade example is fine for your run-of-the-mill implied in fact contract. The government doesn't use implied in fact contracts. So I think that we should just be frank that that's not normal, and that's not how things work. And if we're going to treat those kinds of relationships as implied in fact contracts with who knows what terms, then we're really inviting chaos. And I think that in Smith, this court found that there were important policy considerations to say that express contracts waive sovereign immunity.
Before you go there, I think I know where you're going, but before you go there, what if the university had refused to register the students or had disenrolled them? Are you saying they'd have no contractual, so that they paid the money that's required to register, and let's say there's no, they're disenrolled for whatever reason, but it has nothing to do with their own conduct. They have no recourse then?
So are you saying for like a refund of the tuition that they've paid?
Right.
I guess. Well, I'd note that this case doesn't involve tuition. It doesn't involve room and board. It doesn't involve dining. So,
but what I'm getting at is under your theory, there'd be no cause of action in contract, right? Because you're denying that there is any contract. Even for registration and enrollment, even though the university says you've got to pay these things in order to register.
Yes, Your Honor. We would say that even then there is no recourse. And I understand that that sounds like a harsh result, but the problem is sovereign immunity always has a bitter taste to it. The problem is that the defendant's able to come in and say, regardless of the merits of your claim, plaintiff, you lose, and that's just how sovereign immunity goes. It's essentially a political determination, usually by the legislature, when and whether to waive immunity. And so, because it's a political question, the remedy is really political to call your state legislator, and if you would, and that's in fact what many states and including the federal government have done. They have not gone the Smith judicial abrogation of sovereign immunity route. Instead, they've enacted statutes that waive immunity with conditions and a lot of protections for the government that we don't have in this state.
Well, see, I see your point that when you look at the descriptions of the individual fees, that many of them pretty clearly don't contain any kind of express promise. But there's no dispute here that you're at least entitled to, or at least you're paying them as a condition of registering. So
I do agree with that. I think that's how the statute's set up. We will not enroll you until you've paid the fees.
But you see no legal obligation on the part of the university even to register people who are accepted and pay all their fees.
I don't believe they have to. I think it's a matter of good government and good sense that's not what happens. But no, I don't believe that there's legal recourse. I'd like to reserve the rest of my time for rebuttal.
Thank you, counsel. Hear from the appellee.
Good afternoon, Mr. Chief Justice, members of the court. May it please the court, my name is David Stradley of the Wake County Bar, and I represent the plaintiffs in this action. When one takes money in exchange for something, that person must provide what was paid for. It matters not whether that person happens to be the state of North Carolina. A deal is a deal. And on that point, law and common sense agree. I'd like to discuss 4 points today. First, waiver by failure to raise a number of the arguments that we've heard today on appeal. Second, whether a fee is a tax, which is apparently a newfound argument, although expressly rejected today. Third, that we have indeed pled facts showing a valid, implied, in fact, contract. And fourth, to talk about this notion of this warning that fees would not be refunded. So that's what I'd like to talk about. But first, a brief adversion to history. In 1860, somebody thought it'd be a good idea to try to get letters from the East Coast to the West Coast. So you could send a telegraph to Missouri, and they would put your telegraph on a horse. and send it to California, and that was called the Pony Express. And they managed to do that in 10 days because every 10 or 15 miles they would swap horses. And while that was a really good way to get stuff to California in 1860, swapping horses all the time, that is not a permissible way to argue in the courts of North Carolina by swapping to a new horse in between courts, not only in between the trial court and the Court of Appeals, but between the Court of Appeals and this court. And this court's precedent says that that is not allowed. But what we have here is an evolving notion of what the relationship between students at the University of North Carolina, at Chapel Hill and at NC State, the nature of that relationship. Despite the fact that North Carolina case law is clear that the relationship between school and student is contractual, the Ryan case involving a resident at UNC, the Montessori school case involving a private school, the university eschews the notion of a contract, although that's the argument they made in the trial court. At oral argument at the Court of Appeals, they say, no, this is a statutory relationship. Then in their brief, their principal brief, they're a little coy about what sort of the relationship is, and they talk about taxes. And then in their reply brief, they actually say pretty clearly to me that it's a tax. Well, there's a problem with that. And the problem with that is Article 5, Section 1 of the state constitution, which says, no poll or capitation tax shall be levied by the General Assembly or by any county, city, town, or other taxing unit. Well, what is a capitation tax? Odd term. But luckily, Professor Orth and Justice Newby have enlightened us on that. A poll or capitation tax is a head tax, a flat rate charged on each individual. A capitation, also called a poll tax, a fixed tax levied on each person within a jurisdiction, and that's Black's Law Dictionary. And so I looked at the other side's brief, and they actually say that each of these students, that the fees are charged to each individual student the same amount. And in fact, that's helpful because that's exactly what we allege. That the same student, that all the students pay the same fees. So if this is a tax, it is a poll tax. It is a capitation tax. It is charging the same person, charging each person the same thing, which is not allowed under North Carolina law. You can charge based on income. You can charge taxes based on property. But you can't charge each person the same tax. And as Professor Orth and Justice Newby point out, that such a tax would fall hardest on the least fortunate, because everybody would bear. It's the most regressive kind of tax there could possibly be. So,
but isn't the difference between one difference between a tax and a fee is that a fee is charged to support a particular program, a regulatory program, whereas that's not true of taxation.
Well, that's correct, Your Honor. And I guess I would disagree with my friend. First of all, when you call it a fee, that implies an exchange. As we set out in our brief, the very notion of fee means that I'm paying something and I'm getting something in return. That's just implicit in the definition. But in terms of these local government fees that were brought up, I think that's what you're alluding to, those things you do get something for. I mean, for example, you don't continue to get a water bill if they're not giving you any water. I mean, if the water system is disrupted in the mountains due to the hurricane and it's washed out, I'm not using any city water, so I'm not paying a water bill. If nobody's picking up my trash, I'm not paying a trash collection fee. If the local government charges me a water tap fee to tap onto the local utility water, and they don't ever hook me up, I don't have to pay my tap fee or I get it back. So when these things are, when somebody charges a fee, whether it is a local government or the university I mean, here's a good example. Let's say that I fork over my $40 or whatever it is to Commissioner Goodwin for my driver's license when I get it renewed. And for whatever reason, he just decides that he's not going to send driver's licenses out anymore. Are we seriously suggesting that I have to pay my fee and I don't get my driver's license?
I think what your friend would suggest is there's been no breach of a contract.
Oh,
So you might have a constitutional claim, but not a contract claim. And
well, in that case, I mean, I think we win either way, Your Honor. We pled this in the alternative. Our contract, our pleading below was that there was a contract claim, and if there was not a contract claim, then there was a quorum claim, and the court held there was a contract claim and therefore dismissed the quorum claim. And so if this court is going to say there's no contract claim, then I think we got to go back down and let the trial court deal with the quorum claim. But I guess I would push back a little bit on that there's no contract. And the reason I would push back is because, first of all, we've pled an implied in fact contract, no question, the facts to support an implied in fact contract, no question about it. It's a notice pleading state. We've got a very detailed complaint. And what I think is important to realize, going to the barbershop example, if you look, I think it's in around paragraph 76 of the complaint, page 72 of the record, paragraph 76 of the complaint, we basically say, look, everybody who was at the university knew what these fees were for, and they were getting and they were used to using the services and the opportunities, the health service, going to the basketball games, going to the football games, going to the student union, watching the films, using the discounted movie tickets that are expressly provided for by these fees, and all that stuff was cut off. And so, I do think this is analogous to the barbershop. I mean, the university says, hey, we're going to provide all these services and opportunities, as Chief Justice Newby points out, and then and folks show up and they plunk down their money, and then the university says, no, we're not. We decided against that.
I think the struggle that I'm having with that argument is, let me give you an example, but this is just the basic common law of implied in fact contracts. And the Court of Appeals never mentioned this part of the doctrine, which I think might be how we got to all this confusion. But if you read our case, like this is Snyder v. Freeman, which is one of our sort of main implied in fact contract cases. And we say that you need to have the action. So that's the one thing that we seem to be all focused on, is you may not have the express exchange, but you can tell from actions what it meant. But then the court said, and this only applies where there are circumstances which, according to the ordinary course of dealing and the common understanding of men, show the mutual intent to contract on those terms. And the problem I have here is that in the relationship you're describing, I think it's completely possible that the parties would say they're non-refundable fees. I know that you don't want that to be the case, but you can certainly imagine a scenario where that would be the case, where a university would say, look, we need to keep funding these programs. They're very expensive. So even if for some reason we have problems on campus and we're not going to be able to let you into the library, we're not going to be able to do the on-campus health, we're not going to do our media and newspapers and all those sorts of things, you're not getting the money back. And so it seems like this isn't the kind of barbershop type. There's only one possibility the parties could have meant here when they did this, which is, I'm going to get a haircut, you're going to pay me.
Well, several points on that, Justice Deeds. First of all, that seems like a factual question to me. That seems like something that, when the case law says when an implied in fact contract has been alleged, the terms and whether there's a meeting of the minds is for the trier of fact. So that seems like a factual issue to me. But setting that aside for a moment.
But wouldn't you have to have alleged that then? That was another question I was going to ask you, is going to the swapping horses. I mean, when did you so your clients first assert that this is an implied in fact contract?
I checked the briefing. It's in the briefing to the trial court, which I think is part of I don't know if that's part of the record, but it's in the briefing to the trial court, where we made it clear that, whichever way you go, express or implied in fact, It's a valid contract. As
But I
you
guess
pointed
my
out.
point is there's no what you're describing as facts that could be the subject of discovery, and then you'd have to have a fact finder answer. You would need to allege, though, that that was factually the case, and it seems like the allegations you're making are there's an express contract. They sent us a bill. The bill listed fees and promised us that if we paid these fees, we'd get these services.
Well, you certainly can read the complaint that way, no question about it. But I think you can also read the complaint as this was the long-time understanding of how these things worked at the university. Everybody understood that's how they worked. You paid your fees, you enroll at the university, you get the discounted tickets, you get to use the health services. All of those things are just part and parcel of the bargain, and everybody understood that. And so, again, I think it's very similar to the barbershop example. Now, getting to the no refunds issue, if we're talking about the notice in the email, I think there's several problems with that. But the biggest problem with that is they didn't warn of what they did. They did not say, there's never been any suggestion that they said, if we don't provide student health services, if we don't provide discounted tickets, if we don't provide access to NCAA sports, then you don't get your fees back. What they said was, if we transition to, if we change the mode of instruction. Well, I don't think any reasonable person reading change the mode of instruction would necessarily understand that to mean send everybody home, lock everybody out of the dorms, lock down campuses, and even close the library. I don't think anybody would have understood that, and so I don't see how anybody, again, talking about ambiguities and drafting, UNC whatever that is, UNC drafted it, and if they intended to put people on notice that they weren't going to get their fees back if they merely took Zoom classes as opposed to in-person classes, I mean, there's no reason, there's nothing that is implicit in that says, I got to take Zoom classes, but I can't play intramural sports, or I can't use the gym, I can't use the workout room. I can't get student health services just because I'm taking Zoom classes. So I just don't think that would have put any reasonable person on notice of what actually happened in this case.
But I guess the thing I'm struggling with is everything you just described seems to me to just underscore why this is you've alleged an express contract. Because the point of the barbershop hypothetical is that just in the ordinary course of dealings, in the common understanding of men, no one could say that if you stood up after getting your hair cut and the barber said, $20, and you said, well, I thought this was just, you just cut people's hair for free when you walk in here and sit in the chair. No one would think that. When you sit in the chair at the barbershop and the barber comes over, you don't need to say anything. You have the contract. But here, it's so complicated to figure out what did the parties mean. Was it refundable? What's not refundable? All these things. And so it has to be an express contract.
I guess I don't agree with that, Justice Dietz, because as we've alleged, again, it's a pleading, we're at the pleadings, as we've alleged everybody had an understanding about how these services would be provided and what access you would get to these services, because that's the way it had always been. And therefore we had an expectation interest in the future, and nobody has suggested, there's been no answer in the case. So it's not like somebody has come in and denied that there was this understanding. We've alleged that there was this understanding that everybody was on the same page with this, that this is how it had always worked, just like it always works in the barbershop. Now, as a factual matter, can somebody potentially come in and show that, hey, no, a reasonable person, there's 16 different things this could have meant? Maybe so. But that seems to me to be an argument at summary judgment, not an argument at the pleading stage, when we have pled that there's this long course of dealing, essentially, between the university and its students, and that they had always been treated this way, and then all of a sudden the university decides, for some reason, that these two schools, despite the fact that 14 other schools managed to keep students on campus and keep providing in-class instruction and everything, these two schools just had to pull the plug. That has yet to be, again, we're not in discovery, so there's been no explanation of why that was done.
I'd like to ask you about implied and fact contracts and sovereign immunity. In Smith v. State, one of the justifications that this court gave for waiving sovereign immunity as to contracts was that the state is able to essentially estimate, calculate its financial exposure. How concerned should we be that if we do say that this is an implied in fact contract as alleged and that it waives sovereign immunity, that we could be exposing the state to massive and unexpected financial liability, which ultimately rests on the taxpayers?
Well, I guess I would say that the first thing I would say to that is the size of the contract ought not change the law, and the size of the breach ought not change the legal effect of things. I mean, that's, you know, I mean, we don't say if you traffic a little bit of cocaine, you go to jail, but if you traffic a shipload of cocaine, you don't. It's just a concept that's foreign to the law. So the size of the breach, the size of the contractual breach, really shouldn't have anything to do with that. And second, I would say
this goes to whether we ought to recognize contracts implied in fact as an exception to sovereign immunity at all.
And I would say to you, along the lines that Justice Dietz suggested earlier, that the court has already done that. That the court says in Smith that whenever the case, whenever the state enters into a valid contract, it waives sovereign immunity. And in fact, the law in North Carolina is that an implied in fact contract is a valid contract. And so I would suggest that I think that ship has sailed, that the law is settled on that's not something that the court has to, you know, some new concept the court has to recognize. That is settled law since at least 1998, that an implied in fact contract is a valid contract, and since 1976 that any valid contract waives sovereign immunity. And I will say this too. I mean, this is not the equivalent of tort liability, which would be potentially impossible to estimate. The university knew how much money it collected. It knew that it collected money for these specific purposes, and it knew how many students it had, and it knew it wasn't going to be providing those services to those students. So this is not a situation where they couldn't estimate their liability. This may be a situation where they failed to estimate their liability, but the fact that their failure to plan does not mean that these people should not have a remedy.
I'm sorry to go back, but I just want to make sure I understand how you're arguing the characterization of the First Amendment complaint here, because and this is on the question of whether you're alleging an express contract or an implied in fact contract, because you definitely say, I'm looking at paragraph 98 of the complaint on page 81 of the record. You say that the plaintiffs and members of the student fee class defined above entered into express contracts. So you are alleging that there are express contracts.
We certainly did allege that there are express contracts.
And in assessing 12b-6, we're supposed to be looking at what you allege.
That is correct, but it is a notice pleading state, and the question is, what facts did we plead, and do the facts support any recognized cause of action, even if we mislabeled it? So whether we labeled it correctly as express or incorrectly as express, if the facts add up to a valid cause of action, the 12b motion should be denied.
So then you're saying, in essence, you allege that it's an express contract, but if we find that the facts as alleged, assumed to be true, don't constitute an express contract, that you've also, this would then be an implied in fact contract.
That is correct, Justice Earls. That's exactly what we're saying.
Thanks.
And so,
but I mean, that gets, I'm sorry to keep coming back to this, but that really gets me to what I'm struggling with about this case. An implied in fact contract is not something where when two parties try to enter into an express contract, they have express promises that they're exchanging, but then they don't form a contract, that you come in and say, well, maybe there's an implied in fact contract. That's when you tend to get into implied law contracts, where you say, based on the actions of the party, one party has to do something to the other party, given the benefit they receive. as I understand doctrinally, the implied in fact contract is where you never made any express promises. That the entire contract is just inferred from the fact that no two people would do these things unless it was the equivalent of them shaking hands and saying, I'll do this, I'll do that. And the problem I have with this case is that there's no way to look at the action, sending in some money in exchange for a bill, and say this creates this contract that there's these refundable fees, unless you know all this information about what's going on in the case that has to come from the express communications of the parties about the contract.
I guess I would push back again a little bit on that. First of all, we do have the course of dealing, which is alleged in paragraph 76. So we have that backdrop. And then I think, the other part is, I do think that, at least at the pleading stage, I don't really think when students have been going to the university for decades and paying their fees for decades and getting the services for decades that are specifically lined out, and some of which are quite explicit in terms of what are going to be provided, like, for example, the discounted tickets or the ability to park your car. It seems, to use the parking example, I'm not quite sure what in the world could be inferred by anybody. If that's not on all fours with the barbershop example, I'm not sure what is. You say parking permits $200 and I plunk down $200. That seems to me to be the barbershop or the lemonade stand, just without any question. And in terms of this notion that there was no breach of that contract, the case law is clear that there's an implied covenant of good faith and fair dealing, and that no party will do anything to deprive the other party of the benefit of the bargain. And when you charge me to park, at the Friday Center or on South Campus in Chapel Hill, and I have no reason to be in Chapel Hill, I'm in Waynesville studying by Zoom, it seems to me you have clearly deprived me of the value of the parking that I paid for. And you certainly deprived me of the discounted tickets and the use of the student union and the student organizations and things of that nature that I had every expectation that I would get. And if you look at this, in terms of the court's case law on contracts with the government, if you look at this in terms of the Bailey case, the Falconberry case, and the Lake case, the cases are clear that where the state puts out communications and then people accept by conduct, that is a contractual obligation. This court, I think, unanimously held in the Lake case that there was at least a claim for of a contractual right in the Lake case to the premium-free 80/20 coverage for retirees, created by the state saying this is what's out here, and then people going and doing what the state said you had to do to go get that.
But isn't one distinction that in the employment context, there's no question that there's a contract. You might be arguing about the terms, whereas here the whole question is there a contract? And if so, what kind?
Well, that is true, but the point of those cases is that there was, as I read it, an implied in fact contract between the state and, that's not an express contract. There's nothing in the Lake case that talks about that there was an offer of premium-free 80/20 coverage. Rather, there were these communications that the state offered premium-free 80/20 health coverage, and then the state decided, and people worked for the state in reliance on that, and had this reliance and expectation interest, and this is coming right out of this court's case law, and the court said that is a contractual right, that if there is a substantial impairment of it, that there's a claim under the contracts clause. Which brings me to another point that I think is important, because there's a suggestion in the briefing that, every time they choose not to have a concert or the bus doesn't run on time, there's going to be a class action lawsuit against the university. And this court's precedent amply deals with that from the Contracts Clause jurisprudence. And what the court says, and it comes from the U.S. trust case from the U.S. Supreme Court, there has to be a substantial impairment of the contract right for there to be a claim. And, you know, that's exactly what we have here. We have a complete impairment of the contract, of the services that were contracted for and the opportunities that were contracted for. And this is not about the bus not running on time. This is about complete deprivation of services that were offered and then not provided. So there's absolutely an easy way to draw a line and say, hey, these claims are in and these claims are out. And in terms of this notion of the state, you know, is going to be subject to unlimited litigation, well, I guess what I would say to that is it hasn't been. I mean, it's 2024. This case law has been here since 1998. That's 26 years old. This is from 1976, which is getting close to as old as I am. And there has not been a wave of litigation that has overwhelmed the state in terms of, you know, implied in fact contract claims. And as my friend points out, the state usually enters express contracts. Well, then that deals with the problem. And had the university spelled out exactly what their intentions were in this case and had an express contract, we might not be here. But what they did was offer these things against the backdrop of the course of dealing, against the people going into the barbershop, you know, year in and year out, charge fees for those and then not pay for them. And we believe that is a breach of some sort of contractual obligation, either express or implied in fact. And if it is not, then there has to be some remedy for that. And that remedy would be to remand the case to the trial court for consideration of whether there is a quorum claim, since the quorum claim was dismissed due to the fact there was a contract, that the trial court found a valid contract claim. And of course, a quorum claim cannot exist alongside a valid state law remedy. So for those reasons, we believe that the opinion of the Court of Appeals should be affirmed, and if not, the case should be remanded to the trial court for consideration of the quorum claim. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. My friend says that we should have spelled out the terms of the contract. If this court were to determine that there were a contract here, we certainly spelled it out with the no refunds clause. There's nothing factual about the no refund language, and the plaintiffs agree in their brief to this court that it's part of the contract, if there was one. No refunds means no refunds, and no set of facts is going to change that in discovery, and I can't imagine a clearer way to draft it. Now, my friend also says that we have not preserved our statutory argument, but of course, the statutory argument is just a handmaiden argument, an argument to support our central claim that there is no contract here. We have consistently argued that the relationship between the university and its students is not contractual when it comes to fees. We raised this in the trial court at the hearing on the motion to dismiss. That's transcript page 17. We are pointing to the relevant statute, which is section 116-143. We raised it in the trial court briefing, record pages 115 and 128. It's properly before this court because it was ruled on by the Court of Appeals. It falls within the scope of the question presented by the PDR, and we briefed it to this court. There's nothing more that we need to do to have that argument before this court. My friend's new argument about capitation taxes is wrong. We have analogized the fees to taxes. We have never said that the fees are taxes. Government fees are never capitation taxes, and I haven't found any cases that say otherwise. On the quorum claim, if this court were to hold that there is no contract claim here, should not remand for consideration of a quorum claim, because my friend on the other side did not file a conditional PDR to bring the quorum claim to this court. He appealed the dismissal of the quorum claim to the Court of Appeals, but then he let it die on the vine there. Besides, if there's no contractual interest at stake, which is of course what we're asking this court to determine, then there's no interest protected for a quorum claim. Justice Dietz, I agree with you that this has to be either an express contract or no contract at all. This relationship is too complicated to be treated as an implied in fact contract. The same is true for the government employment cases. The terms of the contracts in those cases were expressed. They were expressed in written statutes. Besides, a plaintiff shouldn't be allowed to abandon one contract theory, plead a new theory, and then start briefing the original abandoned theory. I agree that we are a notice pleading state, but notice pleading means notice. The only thing that this complaint gives notice of is an express contract, because that's what it alleges 3 times. In conclusion, we don't believe that the plaintiffs have valid contract claims either on the merits or due to sovereign immunity. There is no way to cabin the mischief that the plaintiff's theory would cause in the law if the Court of Appeals opinion is to stand, and therefore we ask that this court reverse. Thank you.
Thank you, counsel. Thank you, everybody. Mr. Clerk.
Rise. Yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.